Welcome. Very pleased, Your Lordship. Lordship, I beg to mention for listing of one appeal, Lordship.
Appeal or what?
For orders, Lordship. The IA is pending, Lordship, and it was last posted on 19/2/2024.
Okay, find out the dates and give.
Lordship. Okay. I beg to mention item number 12
12.
for adjournment.
Appeal. You are Mr.
A high on behalf of K. Ravinder.
Mr.
A high on behalf of
A. Ali.
A high. A high.
Hi. Bill or something. Bill or priority na. Bill or something. I to talk. Appellants are on bail. MSP.
Lordship, I'm not
Appellants
aware
are
of.
on bail.
Wait a second. Lordship, I'm
This
not
is
aware of.
appeal against acquittal.
Oh.
Huh? Perhaps appeal against acquittal.
My lord.
Oh, it's an important method.
Lordship. Appeal against acquittal.
Against acquittal. This person are acquitted. Mr. A. High Learned Counsel appearing on behalf of Mr. K. A. Mazumdar, Learned Counsel for Appeal has sought adjournment in the appeal for 2 weeks. MS B. Bhuyan, Learned Senior Counsel and Regional Public Prosecutor for the state. Respondent state. Respondent number 1, State of Assam. Is present and has no objection. Proceed. The prayer so made command by Mr. Ali is allowed. Release the appeal.
Publish.
Release for admission item number 1.
On jail need. Naam क्यों वहां से नाम तो उसको पूरी चल है को instant appeal from instant criminal appeal from jail. The instant criminal appeal. Is directed against a judgment in order. Admit for you.
Yes, are you with us?
Yes. Is directed against a judgment in order dated 14/8/2023. Passed by the Learned Sessions Judge Thomas Soraideo in Sessions Saw case CA case number 30/2023 by the judgment in order dated the accused has been convicted for the offense under section 302 from IPC and he has been sentenced to undergo rigorous imprisonment for them and to pay a fine of rupees 10,000, in default of payment of fine, to undergo simple imprisonment for 1 month. Full stop. On perusal of the case papers, it is found that the appeal has been preferred through legal aid counsel. Full stop. As the name of the learned legal aid counsel is not reflected in the court list, release the appeal after a week, reflecting the name of the learned legal aid counsel. So they are a legal aid counsel. His name is not reflected.
Item number 2.
Yeah. Wait for it. Can you believe it?
May it please. This is an appeal under the NIA Act. Rejecting the bail plan. Here are an important point.
So appeal is a right under 21(4). Yes, we can admit the appeal, fix it for while calling for a scan copy.
Just one more. Hello, you also may kindly see the index.
Index.
The impugn notice is dated 33/24.
33, yes.
24. Then in the cost title, you also will find cost title, now what I will call order dated 23/3/24. Cost title manner. First,
Printing mistake.
that is page, I think, page 1. Page 1.
Or those can be termed as technicalities. They may file amended cost title.
Anyway, madam, we do not know with
We can correct
that
it
is
here.
23/24. Then you also will find.
Nowadays, hand correction is not civil. Mr. Day will file amended cost title.
But whatever it is, my duty to just point out. You also will go to page 18, my lord.
18.
18. Then you also will find copy of order dated 33/24. We do not know all these orders, whether it exists or some or other they have to explain it, my lord. This.
Substantially, it is order dated 23/2020.
That is the order that is annexed, my lord. You'll also will find that is at page 23. Actually, that is the order, but all this correction, they need to correct it. That is one part, my lord. Now, this is a statutory appeal, my lord, provided under the NI Act 21(4). Definitely had to be admitted, my lord. We'll file our return affidavit, my lord, and give us 4 weeks time, my lord. This is the first time that matter has come up before.
4 weeks will be too much. I am in jail for 10 years. And learned trial court did not consider that as well. Moreover, my lord, there is an important point. On the basis of a Supreme Court decision, the learned trial court has denied himself the jurisdiction of granting or not granting bail. It's a very serious matter. I am yet to find a case that the trial court will not have jurisdiction to grant bail or not to grant bail. Because he said that it is the constitutional courts. I don't find anything in the constitutional courts. Even a Munsif is a constitutional court because chapter 6 of the Constitution says about the subordinate judiciary. Chapter 5 for the High Court judiciary. Constitutional courts will very well include the there is no, to my knowledge, there is no definition of constitution. Some of the replies is there
Hmm.
that because constitutional courts is Supreme Court and High Court, because they issue writs, I find it difficult to digest. That has to be decided because
Okay.
that has to be decided because otherwise, my lord, the trial courts are in doubt whether they have got the jurisdiction. This is a preliminary, my lord, Article 21
Yes.
cannot be taken away from the trial court. If I come to your lordship directly, your lordship will go to you go to lower court where the case is pending and see the system of judiciary. For 10 years, we are in jail.
Super, this right to grant bail or not to grant bail under the NIA Act is the jurisdiction is vested with the Learned Special Court. And in one of the judgment I have found that the High Court exercises appellate jurisdiction, but not the original jurisdiction. In case of NIA Act,
High Court cannot have original jurisdiction in this matter.
In this way.
by implication, 439 jurisdiction has been ousted.
Okay.
That is what I could found.
Says that
Anyway, we have to call for the scan copies of the case
Scan
diary
copy,
also, case
evidence,
scan copies of the
including evidence, because here
entire case record.
evidence is recorded. Otherwise, my lord, trial will be
Okay, Mr. Dey,
have to-
take care of the objection by filing additional affidavit.
2 weeks, maybe not
weeks
4
is
weeks.
go-
So, we need-
Stop, my lord. Give us at least 4 weeks, 3 weeks, my lord,
okay.
3 weeks.
Ajiki, right?
My lord,
17 or 17?
May.
May? That is 3 weeks.
my lord,
For us, it is all right, my lord.
scan copy may be provided
Yes.
to public prosecutor and to us also.
We'll call for the scan copy. You can,
No, what?
it will be very voluminous also.
Madam, whatever, my lord.
50, 41, 51 witnesses have been examined.
Oh, we'll call for the scan copy of the case diary. You can go
Yes.
through it.
Yeah,
No,
But it will be permitted.
case diary will not include the evidence.
No, no, no. I am saying that scan copy of the entire case record, which will include the evidence. Right? Heard Mr. A.K. Bhattacharya, Learned Senior Counsel, assisted by Mr. R.D., Learned Counsel, for the appellants. And Mr. D.K. Das, Learned Senior Counsel, assisted by M.S. B.K. Darji, Learned Counsel for the respondent, N.I. Gustav. The instant appeal under section 21 within bracket 4, National Investigation Agency Act 2008 is preferred against an order dated 20/03/2024 passed by the Learned Special Judge NIA Assam Guwahati in Miss within bracket NIA case number 27/2024, arising out of special NIA case number 2/2015.
15.
Mr. Bhattacharya, Learned Counsel for the Learned Senior Counsel, appearing for the appellants, have submitted that the appellants are in custody for a period of more than 10 years. And
Not more than 10 years, madam.
About 10 years. About,
Nine years, my lord. We have
Don't
made a
object
copy.
on this thing.
Huh?
It's a sad story of the judiciary.
about 10 years.
Call it a fair trial.
Full stop. But only
53 with.
53 prosecution witnesses out of the listed
110.
110 prosecution witnesses have been examined till date. Full stop. Para, Mr. Das, learned senior counsel, preparing for the respondent and I has sought for 3 weeks' time to file a reply to the instant appeal. Full stop. Yes, Pada submitted that there are certain typographical errors. Certain typographical errors have been are kept in the memo of appeal. Full stop. Mr. Day, learned counsel assisting Mr. Borsaidi, learned senior counsel for the appellants, have submitted that an additional affidavit will be filed with regard to the alleged typographical errors. Full stop. The appeal is admitted for hearing as Mr. Das, as Ms. Raji.
Index.
I have said this,
Madam.
I am not going. Let them find out.
One.
Okay, as MS Dorji, learned counsel, assisting Mr. Das, senior counsel, has appeared and accepted notice on behalf of the respondent and I, issuance of formal notice is dispensed with. Full stop. For the purpose of consideration of the appeal, scan copies of the case record of special case number
2 of 2015.
issue notice returnable on 17/5, huh? Of special NIA case number 2 stroke 2015
2015.
would be necessary. Let scan copies of the case records of special NIA case number 2 stroke 2015 be requisitions from the Court of Learned Special Judge NIA Assam, Guwahati. Full stop. A copy of this order, register judicial. List the appeal on 17/5/2024.
Hold on.
That is all.
Prima facie case.
Right.
He doesn't exercise constitutional power.
That we have to see.
There are cases have come again.
And that have presented.
Sure, this is not the only case on that ground. The
Madam,
application has been
That
rejected.
to be-
There are other.
That has to be clarified. Madam. My point is that constitutional courts includes the subordinate judiciary also. Though Honorable Chief Justice of India say that we should call it trial court, not subordinate court, or there also I have objection. Constitution says subordinate judiciary. Nowhere is a trial court is mentioned, because government executive magistrates are appointed through APS. Earlier, when the judicial,
CJI has said that don't say it lower court.
he said that is
He
a trial
said
court.
not that. He has not said that don't say trial court. He said don't say lower court.
Mhm.
3 for orders.
I've been appointed as amicus. A paperwork is not ready for it. It is being prepared.
Service. This is under 302. Okay. Heard Mr. A. Kolita. Learn is amicus duty for the accused appellant. NMS and thus learned additional public prosecutor for the respondent. Number one, state of Assam. Full stop. As per office note dated 20/04/2024. As per office notes, the case records from the learned session judge Dibrugarh have not been received, and neither a record nor unserved notice has been received back from the respondent number two. Full stop. Leaves the case appeal after 3 weeks for the record of learned trial court and as regards report of service from the respondent.
Okay. Obliged, lordship.
Number 4.
Learned amicus curiae been found absent to their on call. Whereas MS and thus learned additional public prosecutor for the respondent number one, Thomas State of Assam is present. But it seems same as per office note. Office notes, huh? 23rd.
Let's develop.
No idea. Again, clear, go. Place the appeal after 3 weeks for receipt of record from the learned trial court. Here they are reading 100. Service report is 100.
Item 5.
Also, we image those questions.
No, this is an appeal against acquittal, lordship. Today is coming up for the first time.
concern. Seeking leave.
Yes,
Lordship, leave is not required in this case.
No, cause title. I have cause title.
Because applicants are member of the victim's family. Oh, I like it.
Because he has written it. 373. 378 says no appeal to the High Court under subsection 1 or subsection 2 shall be entertained except with the leave of the court.
without the leave of the court.
Subsection 1 and subsection 2. Subsection 2 deals with CBI. See, subsection 2 deals with CBI.
CBA.
If such an order of acquittal is passed in any case in which the offence has been investigated by the Delhi
Special police
official
establishment.
so-and-so or by any other agency, say NIA, empowered to make investigation into any offence under the central act. So subsection 2 is out of purview. Now subsection 1.
That will be the district magistrate.
So you are wrong in that.
Appeal against the acquittal is preferred by the state.
Now this has to be corrected.
Lordship.
It should be under the proviso to subsection 372.
I will do this.
This leave we cannot grant. You are neither state government nor central government. This is wrong.
I will make that.
This is not maintainable. You prefer the appeal.
I will do that.
This is not maintainable. We hold so.
I will file lordship.
Huh?
I will file lordship.
What?
A fresh application lordship. Fresh application.
Otherwise not required.
Leave
You correct the
cost type.
cost item.
Nowadays
If
it
there
cannot
is-
be done.
Appeal is already filed.
Oh. এইটো কৰিলে এইটো যাব দেখোন। If this goes, that goes. Because that is not bond. Have you understood?
Yes, sir.
You have to file simply an appeal under the proviso to section 372.
Appeal is
If
already,
there is any question of limitation,
Ap-
you take the plea of this.
appeal, accompanying appeal is already filed, Lordship.
No, provision to
No,
full.
question is not that.
That.
Question is this appeal, survival of this appeal is dependent on this,
Lordship.
right?
Lordship,
And when this is not maintainable,
Lordship.
not maintainable,
Lordship.
it is not that case not entertainable. It is not maintainable.
Understand.
In such situation, if it is not maintainable, then when survival of this appeal is dependent on this, that is also, we
I will
cannot
do-
go beyond the law.
I will allow, I will withdraw and file. the petition.
My heart will observe something so that,
Lordship,
we'll observe something so that. We'll observe something so that the handle is there for you.
Lordship.
Heard Mr. A.K. Ganguly,
Yes, ma'am.
learned counsel for the applicant. And MS Vivia learned senior counsel is additional public prosecutor for the opposite party number one, comma respondent. Opposite party number one, comma state of Assam. The instant interlocutory application is preferred under subsection 3 of section 378 CRPC Code of Criminal Procedure, seeking leave to file an appeal against a judgment and order dated 25/01/2024, passed by the Court of Learned Sessions Judge, Nagaon, Assam, within bracket, Learned. In sessions within bracket T-1, case number 14/2014, whereby the Learned Trial Court has acquitted the opposite party number 225, comma, impleaded herein from the charges under sections 147, 148, 342, 149, 302 of the Indian Penal Code. The applicant as the appellant, comma, has referred the connected appeal against the aforementioned judgments and order dated 25/01/2022. Leave under subsection 3. Of section 378 of the code. Can be sought in respect of appeals filed under subsection 1 or subsection 2 of section 378 of the code. Full stop. The appellant, sorry, the applicant herein has approached this court in the capacity of the as the informant, as the informant stroke victim. Okay, your father,
Yes,
Because
My-
family.
my father,
informant stroke victim,
victim.
full stop. As such, comma, live under full stop, the connected appeal. As such, comma, the connected appeal does not fall either under subsection 1 or under subsection 2 of section 378 of the code. And as such, the instant interlocutory application seeking leave is found not maintainable. Post of liberty, however, stands reserved to the applicant to prefer to avail appropriate remedy. Post of. In view of the order passed in the connected interlocutory application, criminal leave petition number 11/2024, the instant appeal stands accordingly dismissed.
Well, Lord,
We have observed.
in the event of the appeal being filed, the period of limitation, that may be, Lordship. Just some observation, Lord.
In the event the applicant prefers, avails appropriate remedy, the it is open for the applicant to seek the benefit of under the Limitation Act 19.
Section 14. maybe.
If any delay is caused in availing such appropriate remedy. Bona fide,
And-
we do not have to observe, it is like a law. Why it is required? I have already observed that reserves. Avail 14.
Number 6.
B. Sharma,
Lordship, three.
Learned Amicus
Not
for the appellant, and MS Andas,
LCR not received.
Learned Additional Public Prosecutor for the respond number 1, State of Assam. Yeah, go to next thing. As per office notes. Date, huh? Similar. File for records not received. Notice not returned. After chiefs. For controlling, for controlling. Second one, control.
7.
May it please, your Lordship. Lordship, this is an appeal against conviction. The respondents have appeared. Respond number 2 is the informant,
Okay.
but LCR has not been
Offense
received.
under
302.
name shown,
Name is shown.
name is shown.
Name is shown.
Yes, anything, so what about LCR?
LCR is not yet here. Reminder may be issued.
Okay. Heard Mr. D.K. Bhattacharya, Learned Counsel for the appellant, and MS Andas, Learned Additional Public Prosecutor for the respondent number 1, State of Assam, postal. As per office note dated 19/4/2024, respondent number 2, the respondent number 2 has entered appearance to Learned Engaged Counsel. And the name of the Learned Engaged Counsel names are also reflected in the clauses, but none has appeared today to represent the respondent number 2 on call. Yeah. In view of the decision dated 9/2/2000, 21, 2024, comma. A reminder be sent for the records of the learned trial court. Please release the appeal after 3 weeks.
Obliged.
Item number 8.
Sorry, if you want to file objection,
Lordship, I will file objection.
the respondents may file their objections to the connected to the IA criminal 168/2024. In the meantime, if so advised.
Item 8.
Eight.
Yes. Well, here I have taken steps, my lord. The office note dated 204, my lord, 2024 says that,
204.
yes, my lord.
Records have been received.
Yes, my lord. But service is not completed there. So, my lord,
Okay.
in the meantime, paperwork may be prepared.
Okay, will ask the SC to prepare the paper.
Yes, sir.
Right, 302, 302. Very from that. Heard Mr. N. Uddin, learned counsel for the accused appellants. NMS N. Das, learned additional public prosecutor for the response number 1 from a state of Assam. As the records from the learned trial court of sessions, Judge Vilasipara have been received from the registry to prepare the paper book. Full stop. As notices to the respondent number 2 has already been sent by registered post 80 on 5/4/2024, and neither answer notice nor ID card has been received back till date, let the case be placed before the Lavazima court to ascertain the status of service of notice upon the respondent number review and could submit a report list their fields after 4 weeks.
Yes, my lord. I'm blessed.
This is the case of
Item number 9.
This one,
yes, madam. Who is
the side is absent, madam. Legal aid counsel.
officer in charge service report? Any service report? 8/4 only, so steps by usual process not taken.
Allow me to
Huh?
take a usual process.
Heard Mr.
P. Bora.
P. Bora, learned counsel for the applicant, and MS B. Puina, learned additional senior counsel and additional public prosecutor for the opposite party number 1, state of Assam. Post of Mr. Bora, learned counsel for the applicant, has made for 3 days time to take steps upon the respond number opposite party number 2 by usual process. So stop the praise allowed. In view of office note dated 8/4/2024, await for the service report in respect of the opposite party number 2, which was sent by registered post on 8/4/2024. Full stop. Raise the case after. Raise the case on video. Emma.
27/5.
Hello.
It will, sir.
Maybe
There are 20 witnesses.
28 witnesses are there, madam.
We can make a start.
Yes.
No. You are amicus.
No, my lord, I'm engaged.
Amicus.
My lord, your lordship will find the FIR at page 4. Incident occurred on 20 of January 2016.
Fire.
FIR page 4. And the FIR was registered after 8 days, my lord, on 29/1/2016 by one Jeet Bahadur Rai is PW 1,
PW.
PW 1, man. FIR was lodged on 29/1/2016, man. Under section 302 and 201 IPC, man.
Let us read the FIR first.
Yes, madam. Humble submission is that around 10 PM on 21/2016, my younger sister Bimala Rai, aged 18 years 6 months, went missing from the house of my paternal uncle on 26/1/2016. Rauta police station was informed of the incident. Later, as public became suspicious of Sri Rishi Ram Sharma, they questioned him and he confessed that he had killed Bimala Rai and kept her dead body buried. After that, taking the public along when he showed the place where he had kept the dead body buried, Rauta PS was informed of the matter. Accordingly, police investigated the matter and nabbed the accused. It is therefore paid to. After the body was disinterred, my lord, this FIR was lost on the next day, my lord. After the body was disinterred on 28/1. Now, accordingly, my lord, page 7 charge was framed, my lord, under section 302 and 20 IPC.
No, it's good enough. No, it's not.
Well,
1 minute.
prior to that,
No, on 26/1/2016,
yes,
police was informed.
informed regarding missing, my lord, missing of the victim, my lord.
Any ZDN pay?
Yes, ma'am, at page 165.
Yes.
165. But that is not as regards missing entry, ma'am.
That is GD entry, my lord.
GD entry.
165.
Yes. GD entry was registered, my lord, on 28/1, my lord.
28.
28/1, my lord, when the body was disinterred by the police. And when all the people of the village were present, my lord, then this was lost, my lord, GD entry.
1 minute.
Well, in page 165 below, the next page is 166.
165, okay.
That is the GD entry. Lost by C. Joypur.
Confessed.
Yes,
Confessed that
it was a telephonic information.
he had killed. Buried after. Very careful, I mean, to CI. Who at the field, we at the field. Want to make out in the course. 8:15, now I have clinic very. Along with friends, so populate your place of occurrence. Now along with CI data, staff have arrived at the place of having the place of occurrence, the staff is from that. Or gathered. Very quick. They have kept the person by the name of Chinta and pardon of the full present, they have been informed us that. Put them the place. Where he had kept it by the name of going to fight after killing her, like on that person. And have interviewed the leader, I kept him from protecting the. Whenever I was supposed to go to play over here from the king. Don't parent the place where the PS on the note. PS.
He was taken into custody, madam, on that day.
No, when what it was dug?
On
When the
28 1.
place was dug?
28 1.
Huh?
From the inquest report, your lordship will
Yeah,
find at page 11111. 111, your lordship.
111.
111, yes. On 29/1/2016, my lord.
111.
FIR was lost subsequently at night.
So it was when?
29 at
29/1.
28 1. Sorry, madam, 29 1 at 3:30 p.m. Time is mentioned above.
So basically information was given on 28.
28. Yes. As per
And as far as GDN case, Richira Sharma was kept apprehended at the place where he alleged to have kept the dead body buried.
yes,
Okay, he was taken to police station thereafter.
here was police station.
Then on 29/1, body the body was recovered.
Body
And
was
inquest was done.
Yeah.
Inquest was done.
inquest was
Then FIR was lost.
FIR was closed.
Three zero two zero one.
Conviction under 301, 302.
Both.
Not both, only 3.
Only 302.
That too, my lord.
What is the judgment?
Judgment is at page number 76, my lord.
What is the discussion on 201?
30, page 108. Oh, I'm sorry, page 107, my lord.
105.
Oh, no, both, my lord. Both. I'm-
Both
Yes, sir. Both, my lord. Page
clearly made out
107.
the case against him under section 201, 302.
Yes.
So both,
both,
and conviction,
page 107.
302, life, 201, 7 years.
Life means whole of life, my lord.
Plus 7 years.
7 years. But while convicting, my lord, the learned session judge, my lord, I convicted him on the basis of, only on the basis of extrajudicial confession.
We'll stick to that.
Yes. But it rejected,
Extrajudicial.
yes. Whereas, my lord, confession was recorded by magistrate, that was discarded. Confession, my lord, I have, your lordship will see, confession statement, my lord, page 95. Session judge discuss, page 94, paragraph 26,
90,
94. Page, paragraph 26. May I read it, madam?
Yes.
Coming back to the present case, it appears that accused Rishi Ram Sharma in his confessional statement recorded by magistrate under section 164 CRPC, though stated that disease was all along with him, but on the later part of his statement, he stated that when he refused to marry her as insisted by her, he committed suicide by tying her neck with a gamucha.
that is in the 164 state.
Yes, it's a recorded matter.
Now, where is the magistrate is examining?
Yes, the lordship
Let us
will,
see.
that your lordship will find. Page 145. Confession statement.
No, no, no. Magistrate was examined as witness.
Yes, yes. Magistrate was examined, my lord, as PW 25,
Okay.
page 47. Timothy Gitali Rao. May I read it, my lord? One
150.
145. One 150 is the my lord, confessed.
Let us see the question also.
Yes. That's from page 140.
Yes, 150.
Yes. May I read it, my lord? I met Bimala Rai about 6 years ago. She came from Sikkim. Her father hails from our village. Bimala Rai and I were good friends. We had an affair at first, but later we broke up. Vimala often made phone call to me. If I did not call her, she got my mobile phone number recharged, thinking that I did not have talk time balance left to call her. She used to give gifts to me. We had a conversation on the day of occurrence. Around 10 p.m., she came to my room. I asked her to come inside the room. When she was about to sleep with me in the bed, her elder brother, Itu Bahadur Rai, came in search of her. Itu called me and flashed a torchlight from outside. The wall of my room is made of tarja. When I gave a response, Itu asked me to sleep and then he left. When I asked Bimala what would happen, she told me that nothing would happen and that she would tell that she was in Pooja's house, her friend. At that time, I got a phone call from Pooja and she said that Itu had gone to her house in search of her, Vimala. I got scared. I asked Vimala to leave, but Vimala did not want to leave. I took her outside so that she could go to the toilet. As soon as she went out of the room, I closed the door, but she did not go away and kept knocking at the door from outside. Since I did not have any other option, I opened the door. Later, we went to a field to have a conversation. She repeatedly asked me to run away together. I did not want to elope with her. I told her that she would take SSLC examination that year and I too had to complete my graduation. But she did not pay heed to my words. When I tried to take her forcefully to her house by holding her hand, she snatched the kukri from my hand and dealt a cut blow on me. When I tried to stop the bleeding from my head, she threatened me that she would commit suicide. Out of anger, when I told her to die if she intended to, she committed suicide by tying the gamusa around her neck. At first, I thought that it was just her dramatic behavior. But when she made some sounds of choking and her hands and feet became stiff, I checked her chest. She died. Out of fear, I buried her under the ground. Next page is the certificate. Now, this confessional was, my lord, discarded, rejected by the action court.
Is it observed?
That is the, my lord,
Why is it
Yeah.
observed?
observation in the judgment.
Finding?
In the judgment, my lord, page 76, page 94, paragraph 26. Coming back, may I read?
Yeah.
Coming back to the present case, it appears that accused Rishi Ram Sharma in his confessional statement, Exhibit 16, recorded by magistrate under section 164 CRPC, though stated that this was all along with him. But on the later part of his statement, he stated that when he refused to marry her, as insisted by her, she committed suicide by tying her neck with a gamusa. Therefore, in the context of having inculpatory and exculpatory statement of accused, this court has no option but to reject the confessional statement of accused Rishi Ram Sharma as inadmissible in evidence. Next paragraph. Now it is to be seen whether other evidence produced by prosecution establish the case against accused. In this regard, it is to be noted that accused made extrajudicial confession before
Okay.
number of proceedings.
Okay.
That is how
Stop that. Stop it. Now let us have the evidence.
PW1. May I take your lordship to PW 19, my lord? One,
Let us have PW1 first.
yes,
Informant.
yes, page 8. May I read it, my lord?
Yes.
Page 8. Jeet Bahadur Rai. I am the informant in this case. I know accused Sriram Sharma, who is present here. This is Bimala Rai was my younger sister. The incident took place at around 10 p.m. on 21, 2016. The house of my paternal uncle Surya Bahadur Rai is adjacent to our house. My younger sister Bimala used to study in one of the room of my paternal uncle house and sleep in the latter's house at night. After having meal on the night of occurrence, Bimala went to the house of said paternal uncle to sleep there for the night. That is the incident. On the day of occurrence, as my married younger sister and her husband came to our house, I went to sleep in the house of my paternal uncle. Around 10:30 p.m., Bimala went outside the house to defecate, but since she did not return for a long period of time, my paternal uncle woke me up. My paternal aunt searched for Bimala outside the house, but did not find her. My paternal uncle and I went out in search of Bimala, but we could not find her anywhere. The house of the accused is situated at a place some 20 to 25 meters away from our house. I have known since 2 years prior the incident that there has been a love affair between the accused and Bimala. When I could not find Bimala, I went to the house of the accused and called him from the outside. Then the accused responded from inside the house, but did not come out. Usually light is kept turned on at the veranda of the house of the accused. But that day the light was not kept switched on. When I could not find my younger sister Bimala, I informed my own maternal uncle Joybir Subba Gurkha Union about it. Being unable to find Bimala, we informed the police station. Later, I lodged a written ejahat with the police station. Exhibit 1 is the state FIR and Exhibit 1 is my signature. During investigation, the police seized one Nokia mobile handset and one Airtel SIM card from the house of my paternal uncle, Surya Bahadur Rai. I put my signature as a witness in the seizure. Exhibit 2 is that seizure list, and Exhibit 2-1 is my signature. As we became next suspicious of the accused, I lost the Azhar Exhibit 1. I came to know from Vikram Chetri that after killing Bimala, the accused had called him to bury her dead body. On being shown by the accused, the dead body was recovered from the place where it had been kept buried. Magistrate arrived and held inquest on the dead body. The police also came there. I was also present at the place where the inquest was held. Exhibit 3 is the inquest. Now cross-examine. When we went in search of Bimala, we found the accused in his house itself. It is not a fact that I did not tell the police that on the night of occurrence, the light at the veranda of the accused was not switched on. When we gave Vikram a slap, he told us that the accused person had informed him over phone that he had killed Bimala and that accused had sought help from Vikram in burying the dead body. Vikram came to the house of the accused around 2 p.m. on 21/2016. I saw it. I did not hear their conversation. Accused was present in his house from 21/2016 to 29/1/2016. The public did not beat the accused. It is not a fact that it is a false that the dead body was recovered upon the same being shown by the accused. It is not a fact the accused is not involved in the incident. It is not a fact since we have a dispute the accused from earlier. I have adduced false evidence. This is PW.
This informant is the brother or brother-in-law?
This is Bimala Rai, younger brother of the deceased.
Hmm?
Elder brother.
Come to page 39. Page 39.
Yes.
PW 19. Paternal uncle. Whose whose house the informant was staying in that night?
Yes.
He says informant is brother-in-law of the deceased.
Yes. Informant.
Hmm?
My lord.
He has said it repeatedly.
Yes.
Twice. PW 9.
PW 19, my lord.
PW 19.
Well.
Page 39.
Yes.
Fifth line.
Suddenly,
Did you take the comma? Jitbahadur Rai,
Where correct?
comma, brother-in-law of the deceased.
who were
When my niece did not come back, then I woke up my nephew, Jit Bahadur Rai, comma, brother-in-law of the deceased, who were sleeping in my house. Thereafter, we made a search to find out my niece, but she remained traced. As the whereabouts of my niece remained untraced, and as such, the brother-in-law of my niece informed the matter before the police.
and later, my lord, police only made third. Police
Now
only
let us
came
see
to.
what, okay, maybe that is wrong. See, Disease Bimala Rai was a daughter of Om Bahadur Rai, right?
Lordship,
PW
yes,
19.
fathers are same.
That is
Oh,
why
oh.
some confusion arose.
Yes.
That is why I asked. Disease Bimala Rai was a daughter of Om Bahadur Rai, and
Bahadur.
Jit Bahadur Rai also says my father is Om Bahadur Rai. So it is not actually brother-in-law. It is brother.
But we, brother. Now, my lord,
Not only single, twice he said brother-in-law of the.
yes.
No, doubt is clarified. Okay.
Now, my lord, At the time of incident, as per PW one, my lord, the
He
appellant was,
referred to PW 19
yes,
and PW 1 Bikram
Vikram is PW 14, my,
14. Let us
PW 14, page 31, my. May I read that?
Hmm.
PW 14, Vikram Chetri. I know accused Rishi Ram Sharma. I also know informant Jeet Bahadur Roy. On 21/1/2016, accused Rishi Ram Sharma called me over phone and requested me to come immediately to his house. I went to the house of accused. Accused offered tea, and I stayed in his house for about 1 hour. He asked for my help. I asked him why he sought my help. Then he told me that he killed Bimala Rai and buried. He asked for my help to bury her properly. On hearing the accused, I became trembling and refused to do so and fled away from the house of accused out of fear. I could not disclose the matter to police because police may involve me. Then I disclosed the matter to the members of Gurkha Student Union, so and so, and others. What accused stated before me. Thereafter, the members of Gurkha Student Association took me towards the house of the accused. I did not enter into the house of the accused. The members of Gurkha Student Association entered into the house of Rishi Ram, and when they asked the accused, he confessed before the members of the association. Accused confessed that he killed Bimala Rai. I was produced before the court. I made statement before the magistrate. Exhibit 10 is my
now
statement.
these members, Joybur Limbu,
Yes,
Joybir,
Joybir.
okay, and Manoj Rai
Manoj Rai,
is PW.
yes, PW 17. Then Kirot Rai,
Hirot Rai,
My lord, its name is not
okay,
not examined. My lord.
and Ram Chetri,
Ram Chetri, PW 18, my lord.
PW 18.
Sanjeev, full name is not given, my lord. Sanjeev
Hmm.
is possibly PW 10,
PW
10, my.
Okay.
And
Did try informant.
Rai, my lord.
Informant.
There is no other, my lord. Maybe informant, my lord.
And Chetra Gautam,
Satra Gautam is, my lord, PW 11, Sokro Gautam. And others. Now, cross. My house is situated at a distance of 20-25 kilometers.
kilometer.
Yes, ma'am. It's given as kilometer.
Hmm.
From the house of the accused. I have my parents and brother. I do not know the phone number of the accused by which the accused called me. It is not a fact that I stated before the police that on being called by accused, I went to his house with Sil Bahadur Chetri. About 12-15 members of Gurkha Student Union members went to my house on 28/1/2016. Then full stop, madam. From 21/1/2016 to 28/1/2016. This is the period, madam. I did not disclose the fact to any person. Accused did not disclose how he killed Bimala Rai and where he buried. While I accompanied the students of AGSU, I was not entered into the house of accused. I do not know what the accused stated before the members of AGSU. It is not a fact that I have deposed falsely. Accused did not make confession before me and I depose for the interests of AGS.
So let us see Gorkha Union.
Gorkha, my lord. Joybur. The PW4 was Joybur Limbu. PW4, page 15. May I read that one?
Yes.
My name is Joybur Limbu. I know accused person who is present in the dock today. I also know Jeet Bahadur Roy. I knew victim Bimala Rai. The occurrence took place on 21/2016. On 21/1/2016, informant Jeet Bahadur Rai came to my house and informed me that his sister Bimala Rai went missing from previous day. I came to know from Jeet Bahadur Rai that his sister had affair with the accused person around 2 years ago. On the next day, I, along with others, went to the police station and informed the police about the missing of victim Bimala Rai. On 26/1/2016, police met me at main shop of number 2 Dhansiri and informed me that the accused was having communication with the victim till the date of missing.
Where from police is saying? Any basis?
Some call records,
Call records
Yes.
exhibited?
some exhibited.
Exhibited.
May I continue? Was having communication with the victim till the date of missing. Police asked me to accompany them to the house of the accused. Accused told the police that he used to talk with the victim over phone, but denied having any connection with the missing of the victim. Police took the accused person to the police station. For making some enquiry, I went to the police station on 29/1/2016. When police told me that Vikram Setri may give some information regarding the occurrence. Accordingly, police gave me the phone number of said Vikram Setri and asked me to contact with him over phone, and accordingly I made contact over phone to Vikram Setri and asked him to meet me at Rauta, but he expressed his inability to come at that time because of his other domestic busy schedule. I, along with informant Jeet Bahadur Chetri, went to the house of Vikram Chetri at Rangapani. On being inquired, Vikram Chetri told us that on 21/1/2016, accused Rishi Ram Sharma made a contact with him over phone at about 10 a.m. and asked him to visit his place. Accordingly, Vikram Chetri went to the house of accused and meet him at about 1:30 p.m. Rishi Ram Sharma asked him for some help. Because Chetri told us that Rishi Ram Sharma disclosed before him that he had killed the victim Bimala Rai and sought his help to get the dead body buried. Vikram Chetri, out of fear, refused to do it and left the place. I then took Vikram Chetri to our village and kept him in an isolated, secure place. We informed the matter to police also. I, along with others, went to the house of accused person. Village people already gathered there. Accused confessed before us and other villagers that he killed Bimala Rai and kept her dead body buried in field. The place is like a Pitoni public colony, Marshland. Accused showed us the place in which he committed the murder and buried the dead. It was around 9:30 p.m. In the light of torch, accused showed us the place. In the meantime, police came to the place of occurrence. We handed over the accused to the police. On the next day at about 10 a.m., executive magistrate along with police came to the place of occurrence. This place was already known to the villagers. When I was also present in the place of occurrence, police got the dead body disinterred and sent it for post-mortem examination. Accused told us that he strangulated the victim. During investigation, police produced me before the magistrate, and accordingly, magistrate recorded my statement under section 164 CRPC. Exhibit 4 is the statement recorded magistrate. Police seized one Nokia mobile handset, model number so and so, one SIM card bearing number so and so from the possession of accused Sriram Sharma in our presence. Exhibit 5 is the seizure list, and Exhibit 5.1 is my signature. Police also seized one Nokia mobile handset number so and so and one SIM card from the house of Surya Bahadur Rai in our presence. Exhibit 2 is the seizure list. In Exhibit 2.2 is my signature. Police also seized one intact mobile handset along with two SIM cards bearing number from the possession of Vikram Sethi. I was also present at the time of seizure. Exhibit 6 is the seizure list. During investigation, police also seized one Nokia mobile handset and one SIM card from the possession of Udar Rabha. Now the cross-examination matter. House of the accused and the house of the victim are adjacent with a common boundary. My lord, very test to the housemate. Accused was not absconding. I did not see when Vikram Sethi visited the house of accused person. I cannot remember the telephone number of victim. I do not know the phone number of accused person and also Vikram Sethi. The place in which the dead body was found buried is at a distance of half kilometer from the house of the accused. It is not a fact that I did not state to police that the accused told us that he strangulated the victim. While confessing the guilt by the accused, his confession was not recorded through mobile, etc. It is not a fact that accused is not involved in the offense. It is not a fact the accused did not confess the guilt before. It is not a fact that I have reported. This is my lord PW.
Other Gorkha Student Union,
Lord, my lord PW. PW6.
Hmm.
Page 90.
Monirat. Okay.
May I read that? PW6, Monira Sethi. I know accused Rishiram Sharma. I know informant Jeet Bahadur Rai. The incident occurred about 6 to 7 months ago. For last 2 years, I have been holding the post of General Secretary of Gurkha Student Union of Rauta. I being the Secretary of Gurkha Student Union, informant Jeet Bahadur Rai informed me that his sister went missing. Then Jeet Bahadur Rai informed the matter to Rauta police station. I was also present with Jeet Bahadur Rai along with other persons. Around 1 week thereafter, I came to know that dead body of victim Bimala Rai has been recovered. While the dead body was being recovered, I was also present at that place. Dead body was in buried
So he
condition.
was the FIR writer,
My lord,
writer of the FIR.
writer of the
He said He said,
Yes,
I wrote the FIR.
yes,
As dictated by Jit Bahadur Rai, I wrote the FIR.
yes.
Yes. Any other Gurkha,
PW
PW?
11, my lord. Chakra Gautam. Page 25. May I read that?
Yes.
My name is Chakra Gautam.
We'll resume at 2.
Yes. Examination. May I continue?
Yes.
Rishiram was reading in degree 4th semester. By residing in our, I was reported about the incident. Rishiram was arrested by police on 25/1/2016 and he was released on the next day by Rauta police station. Thereafter, he used to stay in our residence. I do not know the number of CDR by which the accused contacted with others. I do not know what conversation was made by Rishiram with the village people since I was not present. At that time, area was muddy, Pitoni, where the dead body was buried. It is not a fact that Rishiram did not call the deceased. It is also not a fact that Bimala Rai went to field to fetch cattle and fell down. As a result, she died.
So, Mr. Borua, it appears that the case is based on circumstantial.
The conviction was on extrajudicial.
What are the circumstances? Chain of circumstances which are found to be linked by the learned trial, and which, according to you, is not linked. What are the circumstances there?
My lord, can I take your lordship to the judgment?
Tell me, firstly,
Firstly, my lord, the confession was recorded. My lord. Confession statement was recorded.
confession under section
164.
164.
Yes.
That was discarded.
Now that is the thing, my lord.
No, that was discarded by the learned trial.
Well, trial.
Right? So that is in your favor.
Yes.
Right. But what are the other
The
circumstances?
confessional statement does not implicate regarding 302. My.
No, no.
It only speaks of.
Confession statement
Yeah.
of the accused
Yes.
recorded under 164 PRPC
Yes.
has already been discarded by the learned trial court.
Trial.
Right?
Yes.
That is a circumstance which has gone in your favor.
On in. My.
Right?
Yeah.
So what are the other circumstances which are found to be linked?
Yes.
And which are found to have been completed to bring home the charge under 302 and 201. What are the circumstances? Learned trial
Circumstances,
court has
my lord.
found,
Yes. The
which the
prosecution.
prosecution has established, or which the prosecution has not established.
Prosecution, my lord, could not establish the case under section 302, my lord. Because
Now,
there
what are
was
the circumstances the learned trial court has found?
circumstances, your lordship, then your lordship will come to the conclusion of page 105.
No, that is judgment.
Yes.
What according to you are
Circumstances,
the
my lord,
circumstances?
Yes.
That
court,
there should be a
yes,
chain of circumstantial evidence,
court,
and the chain should be complete. Right? And the entire case is based on circumstantial evidence.
yes,
What are the circumstances which the learned trial court has found to have been established? Right? And this, because there are many points
many
in
points.
the chain. Now, these are found to be linked
Yeah.
to complete the chain. So, what are the circumstances?
Circumstances, my lord, one is
First,
that,
tell me,
yes,
one by one.
first is that, my lord, extrajudicial confession made before the student community. Second is, my lord, that discovery, my lord. Discovery of the dead body.
Hmm.
Buried. Low, my lord, that is not admitted by the evidence, but learned,
Admission of accused not required.
the learned court below, my lord, session court came to that finding that discovery has been proved. As regards, my lord, recovery of the dead body from that
Now,
real
this extrajudicial.
Yeah.
It is hit by which
extrajudicial that evidence of the witnesses have to be seen,
no
because confession is defining section
extrajudicial confession is also admissible.
admission.
Now, question is whether this extrajudicial confession was made to whom?
Made to the, my lord, the villagers,
Made to the villagers or made to the members of the
yes, student committee,
organization.
organized.
Now, this is why it will be treated as tainted.
Because, my lord, first thing, all extrajudicial confession is a very
Your submission should be based on
Yeah.
section 24
section 20.
of the Evidence Act.
Yes.
Right. Now, tell us,
Extrajudicial confession has to be, my lord, truthful and voluntary. My lord. And second thing, my lord, the extrajudicial confession, my lord, must inspire confidence that there has to be, my lord, that there cannot be any other, my lord, suspicion other than that point towards the guilt towards the accused. Now, to prove that, my lord,
that is one fact.
yes,
Merely because of the extrajudicial may
But-
not be, conviction may not be based on solely.
and extrajudicial confession is a very weak piece of evidence.
Okay.
That is
But-
what Supreme Court says. my lord.
But one of the link
Yes. That-
why this is to be disbelieved.
Because, my lord, the statement made by this Vikram Setri, my lord, has been whole, my lord, suppressed or hold up for consecutive for 7 days, my lord, or 8 days. And he has stated in cross-examination that from 21/1/2016 to 28/1/2016 for about 8 days, he has not disclosed it. Although he knows of the thing from on 21, I think, on 2021. And his my lord, testimony was, my lord, that out of fear, my lord. The fear will remain after 28/1 also, my lord. What was the circumstances, my lord? That is the thing, my lord, under which led the, my lord, this, my lord, the appellant to confess. That is not true, that he has committed this incident. What is the
There is
circumstance?
some
One judgment is there, my lord.
some evidence.
Yes.
The fact that this accused is someone suspect
Yes.
during all these days.
Yes.
The police have made a surveillance and found out from the CDR
CDR.
there were calls made
Yes.
between the accused and the disease
Yes.
prior to 21/1/2000. And there were calls made from him or in between Vikram. And Vikram was called, I think, by somebody.
This CDR are not proof, my lord. I have seen, my lord. These are only, my lord, after the incident also there were calls. The CDR does not say, because one mobile was, the deceased was using a mobile of one her friend, Rita, I think. That was the version that she was using the mobile of her friend. So the CDR of which
Discovery of dead body, why?
discovery, my lord.
Which is the finding, the learned trial.
Yes. Page 76. of the plan. My lord, can I read, my lord? Para 42. Page 101. This, this very fact has also been proved by PW 28, Sri Khogendra Nath Hazarika, the one of the IO, who in his evidence stated that when accused was under his custody, he recorded the statement of accused, in which accused stated that he killed Bimala Rai on 21/2016, who was missing since then, and kept her buried, and told him that he will show the place where he buried the dead body, and accordingly shown the place from where the dead body was disinterred. Exhibit 21 is the statement recorded by IO as per information given by accused. The IO in his evidence also stated that dead body was disinterred in presence of additional SP so and so executive magistrate DI Rauta PS, and the entire process of exhumation of the body was fully videographed in a compact disc, which is marked as Exhibit 1. Having seen the entire process of videograph recorded in the CD marked as Material Exhibit 1, it is noticed that dead body was exhumed in presence of police officials and village people. The information given by accused to police while in custody gives specific guarantee assurance that he killed Bimala Rai and buried, and accordingly police exhumed the body from the place as shown by accused. As thus, it can safely be said that prosecution has been successful to establish the case as proof provided in section 27 of the Evidence Act. So this is, my lord, finding is contrary, my lord, because the witnesses, my lord, knows the place. The villagers already gathered, my lord, in the place.
Porua, it was the statement of the accused. That before the IO
21.
21
PW.
as per this 42, paragraph 440, the judgment. But the paper book, it takes.
Yeah.
Point number, serial number 56. Here it is stated that exhibit the DD entry 21.
DDNT.
Yeah.
Exhibit 21. Yes.
Then the exhibit 21. According to this PW 28, it is the statement of the accused.
Exhibit 21, your lordship, is the statement of the accused in the police station.
But the expert is intact, it is the DD entry.
Yes, That is, my lord, I was also referring, my lord, that page 166, my lord, although it is exhibited that it is the statement of the accused, my lord, in
Yes.
police. But it appears, my lord, that it is only a GD entry and no specific written uh, disclosure has been made. Disclosure is not made in writing, my lord, by the accused.
Do you want to say that the requirement of section 27 of the Evidence Act is not fulfilled?
Yes,
That is one of your.
yes. Because information must not be known to the police. That should not be known to the police. That this is the place where dead body is found. This should not be known to the police earlier. But it is already known to the villagers, and villagers informed the gathered in the place of where the dead body is there. There were already 100 villagers sitting there. They called the police. Then again, police came, and this appellant was already held up by villagers. This is the thing, my lord. Again, police took him to the custody in police custody. Then on the very next day, he was again taken back. That is the, my lord, already it is hit by section 27 is not fulfilled, my lord. Because one judgment says, my lord, it should not be, discovery should not be, my lord, in such a manner that it is already known to the villager. It's,
Oh.
so there is no discovery, my
Mr. Borua,
my lord.
as per evidence,
Yeah.
or you have read, disclosure was made by the accused first in point of time to the members of the union. As you have read till now, and maybe one or two villages. Because
Disclosure,
they visited the house of the
Vikram Seth.
accused first to Vikram.
Yes.
After getting the information to the accused. Right? And thereafter, in the meantime, after getting this information, villagers gathered, assembled the place where the body was stated to have been buried. And police was informed thereafter. Right?
PW 19 says, police on inspection and search found that suspicious spot
No,
thereafter.
no. You read, say, what is the main one? Mir Bahadur or something like that. If you
Jeep.
say Vikram,
Vikram is PW 14.
he said, can I disclose the matter to the members of the Gorkha Students Union? Police was not in the picture at that point of time. Joybir Limbu, Manoj Rai, Ram Chetri, Sanjeev, Petra Gautam, right?
Yes.
And other accused. What accused stated before me. Thereafter, the members of the Gorkha Students Association took me towards the house of the accused. I did not enter into the house of the accused. The members of the Gorkha Students Association entered into the house of Rishi Ram. And when they asked the accused, he confessed before the members of the Gorkha Association. Accused confessed that he killed Bimala Roy. I was produced before the court. Now let us see PW4.
Yeah.
What he said.
PW format. Page 15.
See, once police visited, somebody said on 25th also accused was visited.
Yeah.
See, after that call, to inform that accused was having communication with the victim till the date of missing. Police asked me to accompany them to the house of the accused. Accused told the police that he used to talk with the victim over phone but denied having any connection with the missing of the victim. Police took the accused person to the police station. for making some inquiry, I went to the police station on 29/1 when police told me that Vikram Chetty may give some information regarding the occurrence. Accordingly, police gave me the phone number of Vikram Chetty, asked me to contact with him over phone. Accordingly, I made contact over phone to Vikram and asked him to meet me at Rota, so and so, so and so. Thereafter, I, along with informant Joy Bahadur Chetty, went to the house of the Vikram Chetty at Rangapani. On being inquired, Vikram Chetty told us that on 21/1/2016, accused Rishiram made a contact with him. Right?
Yes.
Accordingly, Vikram Chetty went to the house. He said, then next page. Next page. I then took Vikram Chetty to our village and kept him in an isolated, secure place. We informed the matter to police also. I, along with others,
Well,
Vikram Chetty also said, went to the house of the accused person. Village people already gathered there, matlab,
that is-
near the house of the accused. Accused confessed before us and other villagers that he killed Bimala Rai and kept her dead body buried in field. The place is like Pitoni. Accused showed us the place in which he committed the murder and buried the dead body. It was around 9:30 p.m. In the light of torch, accused showed us the place. In the meantime, police came to the place of. So
police,
this confession was not before police.
not before.
If confession is not before police, how 27 will come? Twenty-seven is exception to section 25 and 26, not an exception to section 24.
Now, my lord, the disclosure statement is not the whole basis, man, for conviction. 14, 30, page 31. PW, I have to check, my lord, PW4 maybe.
See, PW 15 also said, very hard. On 25/1/2016, I heard that police took Rishiram to police. And somebody said,
PW 11 also.
PW 11 also said.
Yes, but I know the accused. On 25/1/16, while I was in Chennai, I was reported by my village sister Mayarani that my village brother Rishiram was arrested by police.
Hmm. So something had happened on 25.
Yes.
In it cross also. Only I was reported about the incident. Rishiram was arrested by police on 25/1/2000.
And he was released
Something
on
he
the
has
next.
heard, meaning that why Rishiram was at least under surveillance of police as a suspect.
Yes.
On 25. Disclosure was thereafter.
There.
Not before that.
From 29/1, my lord. Exhibit 21, when accused was taken by the police by the
Exhibit page
place is already known. Place of burial is already known to the people. Arriving,
here the villager said to the police that this is a place accused has told that where he buried the dead body. That is what is emerging from the evidence. That villagers or members of the students union was told by accused that I buried the dead body at a particular place. Having known that, everybody assembled there, but decided not to dig up the place. Police was involved. When police went there, police was told by the villagers that this is the place accused has told. Right? So there was no disclosure made by the accused before the police. The disclosure made by the accused before the
but here one line, my lord, it says that immediately, phase 1, immediately I have integrated Sriram Sharma and kept
that is
him
post
immediately I have integrated
taken into custody.
for taking necessary action. And when I asked him to show the place of occurrence, he has shown the safe. So it was on the very next day, my police stated that it was night on that day. So very next day again he was. Malo PW 28 says, IO, that as darkness prevailed during that time, and as such on the next day, in the morning, in parents was body was
Find out it is 27 is really a problem
yes. And second thing, my lord,
because disclosure is made by the accused
by the
prior to arrival of police that this is the place where I buried. All the villagers arrived there.
and the
So before arrival of police, the place was known to everybody now. Now 27 is for what? That otherwise confessional statement made before police is not admissible.
Okay.
An exception is carved out in section 27 that only the fact discovered that accused had knowledge that dead body was buried here. Only for that purpose. Nothing else. That will not give any corroboration that accused had murdered.
Yes.
Right?
But
Only to
DSP
that extent. But
document-
he had already said, I buried there. That was not under 25 or 20. It was under 24. Now, whether those disclosures made under coercion, force, that will be required to be. Okay, we'll continue from you.
My lord, 29, my lord.
30, we have already picked that.
Can
And
it be,
Yes, it is.
can it be on second, my lord? Any date, my lord.
8th of May then.
That's harder, your
Hard for part-time, hard report. Yes, PPL and Ali, yes, 8 part-time. Like,
Next item,
no, we'll try.
no, Lordship, next item, one of the appellants died. So Lordship directed us to file an affidavit to that effect from the superintendent jail. We have already filed, it's on record, my lord. Flag B.
Three avalanche.
One out of them, three of them, one had died.
We just observed that we are keeping that we have take is
Right.
on record.
Right.
We'll decide. Appeal may appeal.
Right.
Heard Mr. Yami Ladet amicus. You are amicus.
Amicus.
For the appellants and PPL and you complaint regional public. Assisted by NSM. Appeal. Response. Ms. Yeah. That's submitted that. On receipt of instruction from the jail superintendent from a central jail. Guwahati, as regards demise of one of the accused appellants, EIJ Otul Bhuyar, an affidavit has been submitted stating that Otul Bhuyar had already expired, expired on 60/2000.
May I pay
The
for a
state affidavit is tagged with the case record. It's found tagged with the case. Yes.
May I pay for a date? Lordship? They are in custody since December 2020. Lordship. They were under trial.
Under trial?
Under at the time when the trial concluded.
This is
keeping them
2
in
years.
custody.
We are giving preference to 5-6 years.
No, they are in for 4 years.
No,
2020.
2 years. It is reflected in the call.
Appeal is of 2022. They are after the FIR they were taken into custody and since then they are in jail. Page 38 of the judgment part, your lordship will find that.
Page 30.
8 of the paper book. Date of arrest 4/12/2020. Date of
38.
release need.
Page 30 where?
Page 38, down below that your lordship will find the date of arrest, middle portion, your column. Page 38 of the paper book.
Paper book. Date of offense.
Yes, date of arrest, your lordship will find down second table note. In middle portion, accused details is there.
Mr. Ahmed, learned amicus has submitted that the accused appellant are in custody since 4/12/2020. Registry to list the bill for hearing court because by the period of detention we are meaning thereby, to stop. According to him, the accused appellants are in incarceration for a period of
Uh,
about
3 years, more than 3 years.
more than
More
3
than
years. About more than 3 years. I believe. Absolutely.
problem.
Pertaining to item number 10, Your Lordship, the matter was shown that it is non-appearance, Your Lordship. Matter is pertaining legal aid service. Your Lordship, kindly, a date may fixed, Your Lordship. I needed to be heard, Your Lordship. 73 days of delay.
Already signed, madam. All orders. Okay. Your name?
M. Hussein on behalf of A.J. Ahmed.
Mr. M. Hussain, waiting for Mr. A. Ahmed. Now, counsel for the petition. On the prayer. The case is passed over the day. MS work and for the respondent number 1.
What happened in this case? A case was registered against me and other family members for a child marriage matter. And a case under Section
8C for the respondent number 3, 4, and 5. So anybody from state? Please call some state council. Oh, okay. MS S. Sharma, Lion Junior Government Advocate, Assam, for the respondent number 1 and 2.
1 and
LR, Judicial Department,
1 and 2.
1 and 2, and Mr. G. Boshal, Lion Pending Council, Guwahati High Court, for the respondent number 3, 4, and 5.
3, 4, 5.
3, 4.
No, 3 and
3, 4, and 5.
5.
The petitioner, I go to repeat. A petition in this petition is asserting a selection process initiated pursuant to an advertisement dated 10/8/2022. By the advertisement dated 10/8/2022, applications were invited for filling up 11 number of vacancies in grade 4 in the establishment of the respondent number 4. As per the eligibility criteria prescribed therein, the candidates must have passed class 8 or read up to class 12. The advertisement further prescribed that the candidates who had passed class 12 or above shall be ineligible to apply. The petition has submitted that the petition has a qualification of only HSLC examination pass. Thus, the petitioner is eligible to apply for the vacancies advertised by the advertisement dated 10/8/2022. The petitioner has contended that the advertisement itself had prescribed that horizontal reservation in respect of women candidates will be provided as per government rules, and according as per the extant rules, there is 30% reservation horizontally in respect of women candidates. para, Mr. Das Learned Counsel for the petitioner by referring to what is our order of election? Page 34, by referring to the selection order dated 18/2/2020 has submitted that out of you belong to general, out of 4 posts reserved for general category, comma, 1 post should have been reserved for women in view of 30% reservation for women candidates. But such statutory prescription has not been followed in the process of selection. Full stop. By referring to the statement of marks obtained by the candidates in the written and the written test and in the viva voce, comma, Mr. Das has contended that the petitioner had secured the highest marks amongst the women candidates, correct?
As per her knowledge, page 19 is the 74.
You should notice in such view of the matter, comma,
Lordship may
the
also
petitioner
mention
has
the RTA.
petitioner has ought to have been select in place of the respondent number 6.
Respondent number
6. Matter of return it
7-5.
as norma get accepted question 345 the petitioner has accepted having regard to it is observed that the appointment of the shall be subject to the
Public.
Yes, Mr. Chaudhary, because we are giving, actually we are giving this priority to bail hearing first. One bail hearing is there.
CD was called for.
CD not received, my lord.
Then okay, Mr. D.K. Bhuyan. And Mr. And Mr. B.B.
Capacity.
Mr. Bhuyan.
3rd of May.
3rd of May.
Okay.
AP.
11 lordship, we received diary. The petitioner is in interim. His statement is not here, my lord, because diary is not up to date.
Okay, Mr. D.J. Hall. Is present. Sir. Gogoi, B.B. Gogoi, and Tikan Pap has submitted that interim protection on 28/3/2024 with the condition that the petitioner would appear before the IO in 10 days from 28/3/2024. Yes, submit that the case diary received by him, comma, the statement of the petition, the fact regarding appearance of the petition before the IO and statement of the petition, comma, if any recording, comma, are not found available.
Yes, diary is up to 23rd
As
March.
the case diary is not up to date. The Gogoi has not listing of the case on
15
15/5/2024 to return the case diary and to obtain produce an up-to-date case diary on the same day. Okay. This is the case accordingly on 15/5/2024. The interim of the past.
Learned senior person. Last time around the CD was called.
Yes, CD receipt, my lord. That this application is for cancellation of bail. my lord.
For cancellation of bail.
What are the parameters?
Lordship, under section 439(2) of the CRPC, it is said that a High Court or Court of Session may direct any person who has been released on bail under this chapter be arrested and commit him into custody. Any person who has been released on bail, the High Court has the power to be arrested and commit him to custody. The
Who
learned,
granted the bail?
the learned assistant session judge.
Did you approach the learned additional session for cancellation of bail?
Have not approached.
No. Then read subsection.
A High Court or Court of Session may direct that any person who has been released on bail under this chapter be arrested and commit him to custody.
So you have not both have concurrent jurisdiction. On what ground?
Lordship,
What are the parameters for cancellation of bail?
I'll not be fully able to assist the Lordship.
You don't know. There are two distinct concepts. One is for cancellation of bail or to challenge the order of bail. For cancellation of bail, what are the parameters? Fine. I don't think you have taken any of the grounds which is required to be taken for cancellation of bail. Mr. H. Kolita, Heart Mr. H. Kolita. Mr. B.B. Gogoi. And Mr.
S.A. Borbia 229.
S.A. Borbia, Learned Counsel for the respondent number
229.
229. Mr. Kolita has paid for listing of the case after first of the praise to meet. Find out the parameter. If they have violated any of the conditions of bail.
Much obliged.
Otherwise, preferring a revision petition, you have to meet other parameters. Yes, what is this?
Well, the fight between two sisters, my lord. What had happened, my lord? Please come to the complaint, my lord. The elder sister filed the complaint against the younger sister and her husband. Page 13. Actually, what had happened, my lord, I may briefly indicate. This father of this petitioner and number one and the complainant they were employed in the Oil India Limited, Dulia. Entire service career he was there, my lord. He acquired some property in Duliajan and Mora. And he's basically a person from Patsal. Now, my lord, what had happened during his lifetime when he was alive, the property at Moran and Duliajan was given to the complainant. And my lord, the property at Patsala was given to the petitioner number 1. 2, I'm sorry, 2. 1 is the husband. And my lord, in the complaint, there is a reference, some plots of land, which are in fact not in the name of the my lord petitioner number 2. These are property belongs to somebody else. There were some bank accounts, the money has been appropriated accordingly, my lord. Then, my lord, entire COVID period, the father with the petitioner number 2, her husband is a senior officer in the Indian Air Force. At that point of time, she was posted in Rajasthan. Presently, they are posted in New Delhi. Now, in the background, kindly see the background, I mean, the complaint. That the accused are the resident of so-and-so. Now, of course, now they are in Delhi. That the complaint is the elder sister of the accused, Srimati Oli Patgiri Alaman, and is presently residing at Duliajan, Dibrugarh, along with her husband, Sri Sarat Das. That the accused started mistreating the complainant after the death of her younger brother, late Opurva Patgiri, on 5/7/2008, and finally deserted the complainant after the death of the mother. What is the scope of, my lord, desertion, my lord, in a brother and sister relationship? That the accused number 1 is an employee of Indian Air Force and was posted at Mohanabari, Dibrugarh, and had willfully kept the father of the complainant, late Khogendranath Patgiri, in their official quarter, and taking advantage of the old age illness, unhealthy physical condition of the complainant's father, late Khogendranath Patgiri, have been doing illegal acts and conspiracy against the complainant's father's property, thereby making many forged documents to grab the property, and thus did not contact the complainant. Accused have willfully misappropriated landed property of late Khogendranath Patgiri, measuring a plot of land measuring 1 bigha 3 quarters. So, my lord, she mentions about 7 plots of land.
Now, whether
I have filed a reply, my lord, indicating giving the Jamabandi copies, my
okay, this it should be in the name of
My lord.
either Orup Kumar Alaman or Sri Oli Patgiri Alaman.
My lord, in one plot, it is registered in the name of Oli Patgiri Alaman, because she is the younger daughter, and it was given to her.
Okay, when it was
Yes,
transferred?
those are there.
When it was transferred?
Yes, if your lordship would kindly take the affidavit, my lord.
Tell me the date.
One give, one second.
Out of the 7, only one.
In 21. my
Only
lord.
one landed property stands in your name,
Yes.
according to you.
Yes, yes.
Out of these 7
Yes, yes.
landed property.
Yes.
Okay, one that is
Now, please
transferred.
come to para 5 of the affidavit, my lord. Page 27.
Para 5 of additional affidavit.
Additional affidavit, page 27 running. That the petitioners state that their father acquired some properties at Bozali district out of settlement of his ancestral properties, and also acquired some properties by purchase. Out of the 7 properties mentioned in the complaint petition, 2 properties which are in the name of late Khogendranath Patgiri, covered by Doc number 661 and 662, were bought by the petitioner number
Bought
2.
or bought?
Bought.
Bought.
Bought. BOUGH.
Not R.
No. Were bought by the petitioner by executing deed of sale, which was a settlement between sisters, wherein the elder sister complainant would take the property situated at Moran and Duliajan, and petitioner number 2 would take the property situated at Moran. Rest of the properties covered by Doc number so-and-so, the name of the petitioner's father had been deleted at serial number 24, as would be evident from the Jamabandi, as he sold his share during the lifetime to one Deepak Talukdar. In Doc number 488, name of the petitioner's father, late Khogendranath Patgiri, does not even appear. In Doc number 522, name of the petitioner father has been deleted at serial number 7, as he had exchanged his properties with other properties during his lifetime. And in Doc number 283, name of the petitioner's father is still at serial number 7. As such, the claim of the complainant that they have been misappropriated by the petitioner is absolutely false and false. So this is the situation. And now, my lord, a process has been issued, my lordship knows my petitioner number 1 is an senior officer in the, my lord, Indian Air Force. Now, if these facts are brought to their notice, my lord, his entire career will be doomed, my lord. Lord, where are the materials? And my lord, what has happened during the entire COVID time? The father was with me, my lord. That is the petitioner number 2. And he died. There was an arrangement according to which the Duliajan and Moran property was given to the complainant, and my lord, the Ozali property was given to the younger daughter, that is the petitioner number 2. And some LIC certificates are there which have annexed, my lord.
What are these?
Yes, please come to my lord, page number
What about
60.
your submission?
Yes.
These two account numbers
Yes.
and LIC policy.
Yes. Please come to 6, para 6. That the petitioners state that their father, late Hogendranath Patkiri, retired in the year 2003, and thereafter he was living out of his savings without any other source of income. And 2 accounts of UCO Bank were used and maintained by him for his own expenses and medical necessities for his wife and son till they expired in the year 2015 and 8 respectively. Only about 2 years after death of his wife in the year 2017, late Hogendranath Patkiri started living with the petitioner. It is pertinent to mention herein that till 2017, when the petitioner's father, Hogendranath Patkiri, was living in Moran, the complainant was also living in the Moran and had all knowledge and information about the retirement benefits and pension benefits of their father. And now after his death, she is claiming retirement other benefits of her late father. See, actually, my lord, she also lives there. And regarding the policy, my lord, paragraph 7. So, my lord, my humble submission is, before the trial court, day after tomorrow is the date of appearance. What I am respectfully submitting is, lordships will give a, will restrain, stay the further proceedings, and lordships will hear the matter.
So far, we do not go into the veracity of any,
Yes.
we have to see
Yes.
is the complaint
Prima facie,
reveals.
my lord, as far as
Complaint reveals.
Yeah.
And secondly, if in case of unimpeachable evidence,
yes,
right, document,
yes,
we can go into that.
certain.
Now, since the allegation in the complaint is mainly centered around the allegation made in paragraph 6. 7 landed properties.
Yes.
According to you, 5 was never in the name of the deceased, and out of the remaining 2, deed of sales.
Yes.
Deed of sales.
Deed of sale.
Right. That is what you have stated. And so
If
far,
you feel that
LIC,
something wrong, get it.
LIC is-
Filing a suit.
so LIC is concerned, you have said something that
Yes.
there was no such policy.
Yes.
And so far, 2 account numbers are concerned. What is your stand?
I have already indicated in paragraph 6, my lord.
What basically?
That, my lord, until 2017, he was in charge of it. He died in 2017. 20. No, father. 70.
Okay. Yes, what is your
Ah.
basically
My lord.
paragraph 6?
My lord, I
We
will,
will look into it.
my lord, your lordship will just look into one of the matter. Till now, they have not appeared. My lord, now, on the very first day, there was no stay order given. Para 7, your lordship will find. My lord, as your lordship has indicated about the unimpeachable documents, this affidavit was filed yesterday. I didn't get an opportunity to, this affidavit is filed yesterday. All those documents that have been annexed, I have to take some, my lord, at least information from my client, my lord, about this document. And in para 7, my lord, is it not a prima facie case for process, my lord, that the complainant for the late Hogendranath Patkiri was an employee of All India Moran and had accumulated huge wealth, such and such, but the complainant was not informed about the date, and the accused had taken the complainant's father, late Hogendranath, along with them to Chennai as the accused was posted there.
This is too far-fetched that you don't know as a daughter.
And my lord,
Fine,
and
that is too far-fetched.
my lord,
You are
and
not-
opened a bank account. I am on that line, my lord. Open a bank
that is-
account
that is different,
so as
but
to transfer the
author
money of
not
late
knowing
Hogendranath.
the date of the, then it is.
My lord, and they have
all should
transferred
be
the account.
attributable to the
This
author.
this complaint at the prima facie shows there is something in it. My lord, at
You controver
482,
this paragraph 6.
Well, this paragraph 6 about the landed property and others, yesterday only they have filed it, my lord. Let me stop.
Because if it is wrong, if it is as controverted by the petitioner, by the additional affidavit,
Your lordship may,
then it may amount to abuse of the process.
my lord, let it come out, my lord, let it come on Monday, my lord. I will just get the information about it. I will get the information about it.
Not Monday. But
My lord, because these documents have been filed yesterday, my lord.
what is the stage of the proceeding?
My lord, they have not appeared.
Day after tomorrow is the date of appearance. That lordship will protect.
They have not appeared, my lord. They have not appeared till date, my lord.
Yes, yes, of course.
For what reason, my lord, they are not appearing? They are avoiding the trial court, my lord. All this they could raise during the time of framing of charge, my lord. They can raise all these questions before framing of charge.
482 is provided so that
My lord, 482 is provided, my
genuine
lord.
cases
Correct, my lord, I understand.
made shortcut.
In not to cut the complaint with a very short.
You first, also
My lord,
give us
from
satisfaction.
Bhajan Lal to RP Kapoor to all these cases till last, my lord. My lord, everywhere they have said in 482 they should not only on the basis of something they will interfere and
No, in case of documents,
my lord.
there is
2008 14 SCC page 1 para 35 Justice Markande Kartul said that, and it was reiterated in 2013 3 SCC 313. Impeachable, not impeachable documents that regarding a defense in a 482 and 227 they could bring before the court. My lord, these documents, whether they are correct or not, in a 482 the trial the High Court will not look into it. My lord, this is some documents they will bring it before the court and they will say this is an impeachable document.
in what category under the evidence like these documents?
Yes.
My lord, these
Please
documents,
Please answer.
my lord, these documents,
It
my
was
lord,
in
whether
what category?
because the allegation
Public
was,
or private?
my lord, your lordship will just look into. Our allegation was that they have forged the document. They have forged the document. That was the allegation.
No,
My lord,
Mr. Just Rohit, just if what has fallen from that, there are 7 landed properties mentioned in paragraph 7.
my lord,
I have not counted. Out of 7, 5 never belong to the DG.
my lord,
First, please respond to it. He said, out of 7 landed properties, 5 never belong to the DG. And the remaining 2
yes,
got transferred with the execution of 2 stale, registered stale.
my lord.
Now, these are clear statements,
My lord,
right?
clear
Now you
statements
have-
are always made from our side also, my lord. These
That is
documents,
why I am asking you.
my lord, that is why I am also placing, my lord. Yesterday they have served us a copy. My lord, at least I should give an opportunity, my lord.
So, it is, this contention is that
At least, my lord, I should be given an opportunity whether this tail deed is fraud or not, my lord. At least let it come on, my lord, Friday. Suddenly at the 11th hour, they will come and say, my lord, now because tomorrow is the date for appearance, please stay the proceeding. Let them go and appear, my lord. What is the wrong in appearance before the trial court? My lord? What is the wrong, my lord? That I don't understand, my lord. Why is they are so scared of appearing before the trial court? Why they are trying to avoid the trial court, my lord?
Mr. Shuri,
My lord, just for a moment, but if your lordship allows me. My lord, in para 6, it's not only in the case of 7 plot. Along with that, my lord, end of the paragraph, it is stated that, my lord, as well as money from account number such and such of UCO Bank, Chennai branch, and account number, policy of inquiry number such and such, to the tune of rupees 1 crore. They have embellished those money also, my lord. These things are, my lord, prima facie case to proceed with the trial court, my lord. They will.
just have you examined what you had produced at the time of your examination under section 200 and at the time of inquiry under section 202?
My lord, the statements are there. My lord, your lordship will find, my lord, it is there. In the petition itself, they have annexed. My lord, it is stated that the orders are there. Our statement is already recorded under section 200 CRPC. One witness is examined, page 23, examined under 202 of CRPC and is discharged. And on meticulous perusal of statement of the complaint and the witness supported to the annexure 1 to 5, a prima facie case is made out against the accused person, namely such and such, and issue summons. And it was summoned was issued on 13th.
Mr. Shuri, why this interim order was not
13/3/23, more than
My
a
lord,
year.
in fact, what I find, my lord, after I appeared in this case, then I found that, my lord, there is nothing in the petition. That's why I have to file the affidavit.
No. See,
Yes.
question is regarding that interim relief.
Yes.
Because this was listed since September many times.
Yes. Correct. Yes.
It was never
Right.
insisted.
I
5
think, my lord,
occasions,
it was not rejected either, my lord. I think it was
there
not.
nothing.
It was, of course, my lord, I was not there in the proceeding earlier. It will be difficult. What I was given to understand is, my lord, perhaps, my lord, that interim period was not considered. Beyond that, I cannot say anything, my lord, because I was not.
Because
privy.
I was also not seizing of the matter, so I cannot
My
also
lord,
say.
I can only make one submission. My lord, if you want to say that I'm guilty of cheating, then, my lord, there has to be an allegation that from the very beginning I had the intention. Where is it? So, my lord, straight away 415 goes. And your other allegation is regarding, my lord, the landed properties. Well, are these not false statement or no? Is he not liable? Is she not liable under 340 of the CRPC? Well, kindly see, my lord. It's absolutely false statement made on oath. At least before this honorable.
No, we are on the issuance of the process.
Yes.
And the complaint, right?
At
Whether
this
it
stage.
is to be quashed or not, we are not traveling to 340.
I'm just saying, my lord, because my learned friend is
Since
making that submission.
After 5 days now, you are renewing a prayer. Basically, you are renewing a prayer for
Yes.
state.
My lord, only thing is, my lord, because of my husband.
How you have avoided for last 7 months?
No, my lord, we filed applications, a time was given. As a last chance, time has been given.
Okay.
That is how.
Okay. What we can do?
Yes. My learned friend can file. Sorry.
What I am proposing, that since you are renewing a prayer, not renewing basically, it's seeking an interim relief because the case before the trial court is on suspense. And by filing on the basis of the additional affidavit, P.K. Roy Choudhury is asking for at least one opportunity to respond to the additional affidavit. We do it and we provide the opportunity to the petitioner to make an application for an adjournment. We consider your interim relief, prayer for interim relief on Monday or Tuesday, whatever, 7 days, and we'll give the liberty, we'll make an observation because the records are here.
Yes.
We can see.
Yes.
We can see now. This is whether these documents fall in the category of unimpeachable documents.
My
So you can look into.
Yes.
Right?
Or lordships can say that I need not appear on 26. Meanwhile, lordship here the
Council will make an application for adjournment. You are not appearing.
No, I know.
The petitioners in person are not appearing.
So lordship will permit us to seek adjournment on the
Yes.
ground that petition is.
Yes, yes. Because on 5 dates,
Yes.
nothing was faced.
Correct,
Now I have to
correct.
start Mr. Change your as for learned council for petitioner and Mr. P.K. Roy should learned council for the respond number,
Yeah, yeah.
My lord, only one response.
respondent complaint.
Complaint, my
Mr. Chaudhary, learned senior counsel appearing for the petitioners, right?
My lord, two petitions.
Petition. Has pressed for an interim order. On the ground that the complaint case, complaint case number CR-90 Uporot capital C, stroke 2022. Is posted for appearance of the petitioners on
26/4.
26/4/2024. The basis for such interim period is for such interim relief, he has referred to the documents annexed to the additional affidavit filed on behalf of the petitioner. And it is submitted by him that the documents annexed thereto are cannot be are beyond doubt, and which belies the statements made in the complaint, more particularly, in paragraph 6 of the complaint. Full stop. Opposing the submissions of the learned senior counsel appearing for the petitioners, Mr. Roychud has submitted that the additional affidavit, copy of the additional affidavit has been served upon him only yesterday.
Yes,
Okay, he has received a copy of the additional affidavit only yesterday, and he shall be granted an opportunity to controvert the same by way of a reply. How much time?
Let it be on Tuesday, my lord. Or next Thursday, my lord. Next Thursday, my lord, because they have to come.
Okay.
Next Thursday.
Next Thursday. So since no opportunity is since an opportunity court, taking note of the submission of Mr. Chaudhary, has allowed deems it proper to allow the respondent, complainant, to file a reply to the additional affidavit. First of, as sought for by the learned counsel for the parties is the case on Thursday. Since it is submitted on behalf of the petitioners that the complaint case, so and so is posted on 26/4/2024, the petitioners, it is open for the petitioners. Petitioner will have the liberty to prefer an application seeking adjournment before the learned trial court on the ground that, on the premise that the instant case for interim order
Is fixed on.
is ordered to be posted. Ordered to be posted on Thursday.
That
I
is
think that will,
second five, two five.
I think that will suffice.
Mal, I'm deeply.
Yes.
This is a criminal petition. In respect of the
Revision.
Caesar, my lord. The Caesar. The petitioner filed an application before the learned CJM for allowing him to take the custody of the betel nut, 250 bags of betel nut, which is
Betel nut?
the local material. Accordingly, the learned CJM granted the petitioner to get the betel nut out of Jimma. Page, my lord, 30 of the petition.
30.
Page 30.
30.
Yes. This is the
Application.
Page 30. This is the petition. Thereafter, my lord, 3A is my order.
Order at
Order is 34.
34.
Yes. Jimma order was allowed by the learned court below, my lord. Thereafter,
good. Where is 34? Is that
page
call for a report?
Yes, 34.
Call for a report.
Yes, and thereafter,
that is not the Jimma order.
Next, my lord, page.
Rejected.
Yes.
Rejected.
Yes, rejected. Thereafter, the petitioner filed a petition before the Honorable High Court.
Okay.
The Honorable High Court, by an order dated at 11/10/2023, there are 37, my lord.
One more liberty.
Yes, one more liberty. According to this criminal division stands disposed of on withdrawal. However, liberty will remain with the petitioner to approach the learned court below by filing appropriate application. If the betel nut has not been
This order, you preferred an application.
Yes.
Then you made a prayer.
Yes, I made a prayer.
You made a prayer. Please allow me to withdraw the petition.
yes.
What kind of order is that?
Yes, my lord. Next, my lord.
Liberty, if it is available under the law, you can approach.
Yes, thereafter, my lord, page 38. Page 38 is the Jimma order, my lord. And have a look, Jimma order.
Okay, allowed.
Yes, it was allowed.
After recording that it is not local and not quality is cannot be asserted. Okay.
Cannot be asserted.
Very good.
Agriculture Department. Thereafter, what has happened? The state of Assam filed a revision petition before the order of district session judge at Karimganj, my lord. And the honorable session judge passed
Against the order allowing Jimma.
Yes. Thereafter, the state of Assam filed a revision petition before the learned session judge Karimganj. Annexure, my lord, Annexure 7, page 40. On receipt of the petition, on receipt of the notice, the present petitioner filed his written objection.
Then
Written objection
stating that since as per the agriculture department observation that 76% of the betel nut already been destroyed. The now rest betel nuts will be destroyed within a short time. So at least the.
So instead of preferring an interlocutory application before the learned revision court, why have come?
I came before this honorable court on the ground that since
You
the
should
learned
approach when a thing is pending before that court, which has the jurisdiction to pass appropriate order, the basis of, because LCR has already been called for by the learned revision court. See,
Yes. Page
see page
53.
52, oh sorry,
3 and it's the 10.
53, not 50, not 53.
Lordship.
The order earlier to that
Yes, sir.
page 40,
53, my lord.
45. Fixing
Yes,
so
yes.
SR, LCR and hearing.
Yes. And thereafter,
And the
Lordship,
things are
at page
for the,
And thereafter, my what had happened, my lord, I have submitted my written objection before the court.
so have you filed
Yes, I have
any
filed my written.
interrogatory application seeking Zimma?
Yes, my lord, I have filed my written
I
objection.
haven't found anything, any merit in this.
My lord, kindly have a look, page
No
47.
merit.
My lord, I have a merit, my lord. The materials is mine, my lord, and it will go. It is perishable goods. If it will be destroyed,
Perishable, but there is nothing. It is record is clear, report is clear that this is of not Indian.
not this ambiguous.
If it is, if the
ambiguous
report is
opinion.
not Indian or report is to
Not
the
Indian,
effect
my lord.
that it is not of local origin, then what documents you have submitted here in support of such fact?
My lord, kindly have a look, page 40.
Except your GST certificate.
My lord, justice
Or
at my.
this report,
I have.
District Agriculture Officer, page 38. Seized betel nut is not local.
yes.
Clear and unambiguous report, not local. Then
Page
show
30.
us your import document.
My lord, this is I have agreement with the landlord with the owner of the betel nut, my lord.
Show us. Now, this is contrary. You have agreement with the owner of the betel nut.
Yes, my lord.
Right?
Yes.
On the other hand, District Agriculture Officer has submitted a report that this betel nut, basically Areca nut. Areca nut is not local.
My lord, in the from report it is appear that seized betel nut is not local in quality and could not be ascertained. Could not be identified. What is the report he has given, my lord?
Indian system does not have the
My lord, thereafter what?
infrastructure to test the quality of
That
imported
is
Areca nut.
my lord.
In fact, I have been told that forensic science laboratories have stopped.
Yes.
Have stopped
My lord, in my paragraph 49 last part.
analyzing Areca nut.
My lord, in my petition 49 last part, my lord.
Why don't you avail the opportunity before the learned session judge? Why you have come rushing to this?
My lord, because session just fixed the case on 33 2024, it was too late for me. That is why I approached before you.
Lordship, kindly come to
Instead of
page
approaching
53.
the revision court where the entire case is pending.
Yes, already LCR received in the trial court.
Right.
Page-
Here is received, all
page
records
53, Lord.
original were there.
Yes.
And you are contesting the revision petition.
Yes.
Now, why don't you file an interlocutory application seeking order of Zimma for the remaining part of the Areca nut? One part has already been destroyed. That is the case.
Yes.
When it is the order is that it is not local.
My lord, I have placed in my.
We give liberty to you to approach. I find no merit at all to enter in this case. Heard, Mr. Itel. Learned counsel for the petitioner. Yes, that's it. learned additional prosecutor for the response. The instant criminal petition under section 48, Code of Criminal Procedure is preferred to essay an order dated 30/01/2000. What you have said?
Lordship, kindly come to page 53 and answer 10.
31/2000.
31, 2024, page 53 and answer 10.
Yes, Mister. You have challenged what?
My lord, this,
I have found no illegality in the state impugno.
my lord,
Ah,
the order dated 31/2024.
It's for hearing, not
31/2024.
I thought that you have challenged something. I have heard you. Come to page 53. Come to page 53.
53, yes.
Read.
Revision is represented, notice opposite return after service. Opposite party appeared and submitted written objection. LCR is received, fixed 33 to for hearing.
For hearing.
Yes, my lord.
What illegality?
So my lord, 33, that is.
Revision
so too late.
is what?
For.
Huh?
For release, for.
No, there was never a prayer. There was never a prayer, Mister.
Yes. For giving Jimma, my lord.
Huh? There was never a prayer. You have challenged this order.
Yes.
What is the illegality? Correctness, legality, or propriety? So, what incorrectness, what illegality,
My
and
lord,
what impropriety?
my
Tell
lord,
me.
that my lord, this battle net will be destroyed. That is why.
You
I
have
have
challenged
taken-
only this order, will confine to this order. Because your objection is that
Yes.
it is prayed that your honor would be pleased to reject the instant revision petition and pass necessary order as your honor deemed fit and proper.
Hmm.
Page 51.
Yes.
In
Yes,
the
ma'am.
objection filed by you
Yes.
before the revision court. To assail an order dated 30/01/2024 passed by the learned Session Judge, Karimganj in criminal revision number 02/2024. Para. The criminal revision petition, criminal revision number 02/2024 is preferred, has been preferred by the state against an order dated 2/11/2023 passed by the learned Chief Judicial Magistrate Karimganj in connection with ZR case number 460/2023, arising out of Bajari Chara Police Station case number 43/2020. It is pertinent to mention that it may be mentioned that in the course of investigation of Bajari Chara Police Station case number 43/2023, 250 bags of betel nuts. It should be Erica nut. Erica nut. Within bracket, Erica nuts. Weighing 12,500 kgs, were seized by the in charge, Nagara Police Post under Pejeri Sera Police Station. An application was submitted by the instant petitioner before the learned Chief Judicial Magistrate seeking custody of the seized betel nuts, in bracket, areca nuts, and those sworn of other details as to Chelsea RN. Comma. During the it is found that during the course of the proceedings before the learned Chief Judicial Magistrate Karimganj, in respect of the petition filed by the petitioner for custody, comma, a report from the district agriculture officer Karimganj was submitted to stop. In the said report of the district agriculture officer, comma, Karimganj, comma, it has been reported that the seized betel nut areca nuts appeared to be not local and its quality could not be ascertained. Full stop. Recording so, comma, the learned Chief Judicial Magistrate by an order dated 2/11/2023, comma, allowed the prayer of the petitioner for custody, or allowed the prayer for custody to the petitioner on the condition of furnishing a bond as per the value of the seized article. Agreed by the said order dated 2/11/2023, comma, the revision petition, criminal revision petition, comma, criminal revision number 2/2024 was preferred before the Court of Sessions, comma, Karimganj, and the state by an order dated 17/1/2024, comma, the revision petition, the learned session judge Karimganj admitted the revision petition and called for the records of the learned trial court. So, by the said order, comma, notice was order for issuance of notice to the petitioner as the opposite party in the said criminal revision petition. Notice was issued. Where in the aforesaid, in the above fact situation, comma, the learned Sessions Court, Sessions Judge Karimganj has passed the following order on 30/11/2020.
One.
30/01.
Yes.
2020. Case 15. Liquidated. The learned counsel for the petitioner, by the said order from perusal of the said order dated 30/4/2024, comma, it is clear that the learned Session Judge Karimganj has posted the criminal revision petition on 30/3/2024 for hearing. So, the learned also having regard to the order dated 30/01/2024, comma, this court on ongoing this court does not find any incorrectness, comma, illegality or impropriety in the order dated 30/01/2024. Full stop. Consequently, comma, this revision petition is found to be devoid of any merit and is liable to be dismissed. It is accordingly dismissed.
My lord, the petitioner at liberty to contest. Petitioner,
30/3/2024.
That
We
is
don't
pending,
know
my lord.
What has happened?
it is pending before the court.
We don't know. Always you are the party, you are to advance your argument. You make all the argument. I have found that fixing the case for hearing, there is no illegality. Nothing, no impropriety. You have not challenged that I have made a derogatory application seeking Jimma of the remaining Rekanat, and the
This was
learned
not mentioned in the,
revision court
in the revisional court.
did
Yes.
not grant a state fair.
Yeah.
That is not your case. Your challenge is that order. Be
Like-
careful while filing a revision petition. What is this?
There is an note that says that.
The matter has already been disposed of on 6th of February.
This was disposed of, time was granted to the district judge to dispose of the matter in accordance with the direction contained in the order.
This honorable court granted 2 months time. Just
Seeking an extension of time.
That order, that very petition
Has been disposed.
was specifically assigned to a coordinate man.
Yeah.
And that coordinate man had already disposed of
Yes.
by passing a judgment.
Yes.
Yes.
On the basis of a letter, how can it be?
it should have been an interlocutory.
It should have, yes, well, it should have come to the lawyer and then the,
You take your instruction if you are a counsel in the
this matter, yeah. I'll take
because we cannot pass any order on the basis.
letter from the judge.
It should have been addressed to you,
Yes, well,
not to the court.
yes,
And this court is repeatedly saying that address the letter to the court direct. The judicial officer
Yes,
writing
very
letter to the high court that has been wrongly placed. Firstly, it is wrongly placed before this court. Secondly, there should have been an application.
Yes.
Seeking action. Yes. That should precede, application should precede, and thereafter before the appropriate.
appropriate.
Had it been an interlocutory application, I would have no objection at all.
I'll take it.
Where to pass the order? Okay, what we do? We keep it left over. Because today morning, Registrar Judicial has inspected the record. In fact, he has said it has been inadvertently listed. So we keep it left over, appropriate order will be passed by. He has said that it was inadvertently listed. So he'll pass it. We keep it left over. Because in a disposed case, I cannot pass any order.
Yes.
There is no application.
And now I'm appealing.
Your names will be reflected. You'll have material instructions, no issue.
There is order, Lozima court, that order, it is completed, service completed.
So we can do it on admission. That part is now over.
Yes.
Now your final order. And today is not possible, Mr.
Yes, my lord,
But that process is over.
Yes.
Heard Mr. S.K. Medhi, learned counsel for the petitioner, and M.S.H. Bora, learned additional public prosecutor for the respondent number 1, State of Assam to stop. As per order dated 22/4/2024, service of notice upon the respondent number 2
and 3. Yes, 2
and 3 is complete. So the office to list the case for admission on availability of your
30/30 April 30. Because my last date, my lord, there is a order, my lord, prayer for interim relief is kept open considering the
30,
next date.
30 for 2024.
Yes.
The prayer for, we'll repeat that. If some region or other we cannot dispose of,
Yes,
we'll,
ma'am. Yes, ma'am.
now it is service is complete now.
Yes. Yes.
The prayer for interim relief is kept open for consideration on the
Yes. I'll-
1 minute, Mr. Medhi. Kunina Kola.
Thirty.
Let it be on 1st of May.
1st of May is a holiday.
It's
No.
No holiday.
Yes. Yes.
If you want to take holiday,
No,
it
no,
is
no,
different.
no, no, no. I'll-
Part
Maybe
heard.
Lordship was about to dispose of that IA for suspension of sentence, but that delay part, Lord. I filed the additional affidavit, Lordship. That is on record. Appeal has been already admitted, Lord. Order was also dictated, but due to Lordship delayed, Lordship.
Yes, MS Bora. Sentence
That
is
is
up,
controlled.
maximum is
1 year.
1 year, Lord.
Hart, Mr. N. Hassan. Counsel for the applicant. Somebody appeared earlier date, not half.
Respondent.
Yes, what do you say? MS H. H. Bora, learned additional public for the opposite party test. And MS B. S. Kakoti, learned counsel for the opposite party test. You contest the appeal, connected appeal on merit. The instant interlocutory application under section 389 within bracket 1 is preferred, seeking suspension of the execution and for grant of bail. The applicant as the applicant has preferred the connected appeal, criminal appeal number 88/2020 under section 374, CRPC against the judgment and order dated 3/6/2014 passed by the learned additional station judge, Nogam in station case number 111/2008 by the judgment and order dated 3/6/2014. The connected appeal, criminal appeal number, has already been admitted for bail. What is your affidavit?
It is on record, Lord. Flag mark.
The connected appeal was referred on 19 to 2024 along with an application.
Just referred on 13 to.
Section 5 of the limitation seeking conversion of 2784 which had occurred in preparing the post of by an order dated 11/2000 passed in the state of by an order dated 11 comma the state interlocutor was allowed. Accordingly, the connected Fair. It is averred that after the judgment and order state mechanic the learned trial has been issuing non-bailable warrants for taking the applicant up. The applicant order averred that in the year 2000, since the year 2020, he has been suffering from cerebrovascular accident and when the warrant was sought to be executed, the executive authority had found the applicant appellant bedridden due to left-sided hemiplegia caused as a result of cerebrovascular accident. A disability certificate dated 10/2000 issued by the Joint Director of Health Services is found next to the instant application for the state disability certificate, the applicant appellant is has 45% permanent disability in relation to his post CPA residual in the left-sided limbs and he is it is a case of locomotor disability. Having considered the above aspects, So what is the offense? It's trespass.
Darking houses, but
Parking and modesty. And the period of the sentence which are ordered to run concurrently. A prime minister for allowing him to remain
to go on praise bill.
union
Praise bill.
to go on for suspension of that passed by the judgment passed by the verdict and allow him to release bail according to the suspend execution passed by the and the event of party is ordered taken at the event of party in how
Arresting. Arresting authority.
arresting
To the trial court.
Trial court.
Trial-
Yes,
trial.
trial court.
Additional sessions of
Additional
FTC.
sessions,
But
FTC. No, no.
the learned trial property the court of
FTC.
which must be of a life.
Oblige.
Mr. Pathak, possibility of time to proceed again.
No.
13 and 10 are is the IH.
Mr. Ekalagor, as support. Mika. Yes. Please, wherever lesser cases, we'll take. For party.
I